Sir Brian Leveson has proposed that some trials by jury could be dropped. I'm Ollie Mann, and this is The Week Unwrapped. Felicity, tell me more.
Well, thousands of cases that would normally be heard by a jury should be heard by a judge. And that's according to proposals that were published this week by former senior judge Sir Brian Leveson.
Leveson Inquiry fame?
Exactly, correct. Sir Brian has rightly identified that the entire system is in dire straits, and he is arguing that we need fundamental reform to reduce the risk of total system collapse. And that's partly due to an insane number of backlogs of cases. So
give us a number, define insane.
I think it's somewhere between 77 to 80,000, and that's expected to rise to 100,000 without radical action.
Wow. So these are people waiting for their court case for years.
Yeah, exactly, years. So in London, people are being told that their case won't be heard until 2029, and these include rape cases, sexual assault cases. Entire lives are on hold because they're just not getting their case seen to.
And so the thrust of his proposal is don't have juries on so many cases, and then we can get through the backlog quicker.
Yes. So it's kind of complicated. At the moment, the most serious cases can only be tried in the Crown Court, and the least serious cases are heard in the Magistrates' Court, but a large number can be tried either way. There's quite a few things that he's suggesting, but this one is the one that's making the headlines. He's proposing an intermediate court, which would deal with some of these cases, those involving a maximum sentence of 2 or 3 years. And the offences that would be heard in this kind of intermediate court would include theft, the handling of stolen goods, criminal damage, and some forms of assault. And also a very kind of popular one is complex fraud, that he's arguing should only be heard by a judge because, ordinary people just don't understand simple fraud, let alone complex fraud.
Okay, so just leaving aside the merits of whether jury trials are things we want in all cases that they currently happen, Jamie, the practice of setting up a new court doesn't sound like an easy solution. That sounds like a complicated administrative thing to do.
No, and I think it's worth, when you're thinking about the kind of Leveson, the terms of reference for his report and for the recommendations that he set out, the government actually said that he couldn't recommend increased funding. What they wanted was recommendations on systemic reform. Basically, he has said that the backlog is caused by kind of chronic underfunding from government over the course of the last 20, 25 years. But the government isn't allowing him to say that we need to put more money into it. They want other ideas. And when you kind of see it through this lens, because Felicity's right, there are a huge number of recommendations, some of which are probably very interesting. And, I've read some barristers gone on Twitter saying that actually he does recommend quite a few, important ways to change the system. But the thing that was always going to get the most attention was the removal of jury trials for some cases. And it is about money. One of the examples that one barrister that I read was suggesting was that actually the number of days that the Crown Courts can sit is capped. And I didn't know this before I read into it. So it's currently capped at 111,000, which obviously sounds mad when there's only 365 days in a year, but it's around the country. And so some places just can't actually sit on as many days as they want to, and a lot of courts are closed. And so if they change the cap on that situation, then maybe we could get through more cases, was one of the examples that these people put up. But I am, we'll get into the merits of it, but I am quite shocked that this could be coming about, because I do kind of see jury duty as being one of the kind of last vestiges of the way that we interact with the state and the way that we kind of perform a duty as citizens. And this kind of acceptance, if it is accepted, obviously we have to be clear that this isn't law. These are just recommendations. There's no guarantee that it will get through. But if it is accepted, it is quite shocking.
Have you ever sat on a jury, Harriet?
Yeah, I have. And actually, I think that I see it slightly differently. I see it through that lens of personally sat on a jury and quite a serious criminal trial. And without going into too much detail, although I was very excited, as Jamie says, to kind of participate as a citizen in our legal system, what I actually experienced in my time on a jury really damaged my faith in our legal system. And I can only speak from my own experience, not anyone else's, but I was really disappointed and kind of frankly astonished with how I experienced a jury trial and the kind of ridiculousness of having certain types of cases heard by non-experts and decided on by people who may have represented the community, but also were kind of chosen at random from that area. And they were all essentially middle-class, white, English heritage jurors adjudicating on a trial that involved racially aggravated assault.
Yeah, but hold on, that's more likely to happen in the judiciary, isn't it? It's more likely that the judges are going to be probably upper-class white men.
One of the main arguments for the pros of a jury trial is obviously that it's meant to be more representative and fairer and kind of a wider cross-section of society. And I do think that there are really strong arguments both for and against jury trials, and we can go into those in more detail. But personally, serving on a jury, I found it to be a profoundly dispiriting experience.
There's been so many sort of like infamous cases of juries just getting it horribly wrong. And part of the downside, I suppose, with having a jury is they never have to give their reasons, and you never know what's going on behind the scenes. Whereas if you have a judge, they do have to give their reasons. And obviously judges aren't free from bias. But I was thinking about the Vicky Pryce fiasco in 2013, which has got to be one of the most notable examples of a total jury fail.
So this was the wife of the Liberal Democrat Chris Huhne, and she took his speeding points.
Yeah,
right?
She was...
Interesting case to bring up. What was the issue?
Well, she was accused and eventually convicted of perverting the course of justice for taking these speeding points. But the jury kept on coming back to the judge with so many basic questions that they had to ask what the definition of reasonable doubt was. And the judge said reasonable doubt is reasonable doubt, basically. And they also asked, can a juror come to a verdict based on a reason that was not presented in court and has no facts or evidence to support it, either from the prosecution or defence? So, had completely not understood what their purpose was for. And also a very, very famous and quite funny case in 1993 of jurors who consulted a Ouija board. That was R.V. Young, who decided it was a murder case, and they decided to consult the spirits of the dead to find out how they'd been murdered. And that is actually true. You can see that there are problems with juries. A lot of people say that they are also, part of our national identity. That's partly why I chose Rupert Lowe as my clip, because obviously this feels like something that Reform are going to go big on, because, people like to say it goes all the way back to Henry II and the Magna Carta, and this is part of our civic duty and what makes us as British.
Yeah, that's interesting, isn't it, politically, Jamie? This is very much the sort of cause célèbre that Reform like. We are anti the idea of removing juries because juries are a fundamental British right. But at the same time, political parties like Reform like to be tough on law and order. And as Felicity was suggesting there, actually, having a jury of your peers decide whether or not you did it, and you can influence them using charm and wiles, it's more likely you're going to get off, even if you did do it, than if a judge sort of coldly and sort of impartially weighs up the facts, some argue.
Yeah, I think that the argument for getting off is less strong than being convicted if you're innocent. I think most people would say that in terms of justice, convicting innocent people is perhaps worse. This is my broad brushstrokes assessment based on Reform's potential voters. I really do see Reform taking this up as a cause célèbre. I think that the arguments that Harriet and Felicity make about the kind of education of the people on the jury is more of an argument for better education of people at a younger level to understand their role in society than it is to get rid of juries. I fundamentally believe that 12 random voices from society is always going to provide a fairer outcome than 3 narrow, as you said, a lot of the time it will be judges that are court judges that are volunteering to then sit in these criminal situations. They might have to see so many cases day after day that eventually they'll get kind of tired, and that's natural. My worry with getting rid of trial by jury is that we end up in a situation a bit like we were discussing last week, where yes, maybe this government takes this on and just removes it for some offences, but the next government might remove it for all the offences, and we could be in a much worse state from that perspective.
I think it's just fair to clarify that we're not talking about doing away with jury trials for the most serious cases. So those, for example, that involve murder or rape or severe violence and assault or sexual assault, they would still be heard in a Crown Court in front of a judge and a jury. What we're talking about, these proposed intermediate courts, they would hear cases that are the so-called either way offences that we were outlining, so that already a defendant could choose for their case to be heard by a magistrate or a Crown Court with a jury trial.
So what kind of offences are those?
So that would be stuff like dangerous driving, minor drug offences like drug possession, theft, non-serious assault. The cases that at the moment, they make up more than 50% of the Crown Court backlog. Leaving aside whether a jury trial is fair, they are very expensive. They are very, very expensive. They are also they can be very inefficient, because if a jury is not able to reach a verdict unanimously, if they can't agree or they deliberate for hours or days, that usually results in a retrial with a new jury. And in those cases, the defense would be at an advantage, because the prosecution has to surprise the defense team with new evidence. But the defense can use the knowledge of the evidence that was presented at the first trial to block all the prosecution's attack and amend what needs to be changed to make a stronger case.
Also, the jury are thinking, aren't they? Whether they're supposed to or not. They couldn't decide the first time round. This isn't clear cut.
It's unfortunately there are issues logistically with a jury trial that have nothing to do with fairness. They're also to do with the procedure, and the fact that a jury trial means it materially increases the chance that you'll be acquitted of a crime, because as we were saying, it's much more difficult to reach that threshold of beyond reasonable doubt, agreeing that among 12 people as opposed to one judge agreeing that alone.
And of course, Jamie, there's the risk that it doesn't happen at all. We're all talking about this like it's a fait accompli, but the last time Leveson had his inquiry, not all of that got put into place, did it? I mean, this can be a recommendation that's then put to one side.
Yeah, absolutely. The government is expected to endorse the plan, and they'll introduce legislation later in the year. But as the clip showed, there'll be kind of constant issues, and MPs will bring up amendments and things like that. So yeah, there's no guarantee that this will happen. I think the other thing that we should probably talk about that we haven't really touched on is that if we do open these intermediate courts, a lot of the time they'll be dealing with people that need legal aid. The provision for legal aid or solicitors that can provide legal aid has shrunk by a third in over a decade, which means that a lot of people are unable to find, that's what's causing some of the delays, is the fact that people can't afford representation, and the representation that the state provides isn't available, or they have to cover so many different cases that they can't get to every single one. Obviously, this is a problem that can be solved by extra funding. Where that money comes from and how you fund this is a political choice, but I mean, politics is all about where you choose to fund.
We also haven't mentioned the fact that this wouldn't be a judge in an intermediate court by himself or herself. The judge would also sit alongside two magistrates, and those can be anyone. Anyone can become a magistrate. You don't need legal training. You don't need any specific qualifications. You get a legal advisor in court. You just have to be between 18 and 74 and prove that you are of good character and are committed to serving the community. So there is still an element of the general public being able to be represented there as well.
Yeah, but only the type of members of the general public who put themselves forward to rule on other people.
you could do it, Ollie. You could do it now that the
I would
Reader's
do
Digest
it
dropped
totally
off.
appeals to me.